All right, Tim, also a rollover crash in Superior Township kills 2 teenage girls and sends a third to the hospital in critical condition. Topping our news on this late edition tonight, that accident shutting down Superior Road between Huron River Drive and Getty's for hours.
Maura McDonald is at the Washtenaw County Sheriff's Office tonight. Maura, police believe the teens were involved in a hit and run prior to losing control of their truck.
Kimberly Devin, yes, that's what the preliminary information from the Sheriff's Department suggests, that the girls in this truck hit another car and didn't stop. The wreck took hours to investigate and finally clear. What's left of what the 3 teens were driving appears to be a pickup truck. Police say they know speed was a factor, but they also wonder whether these railroad tracks are what caused them to lose control.
We haven't had a really bad accident in a while, but it's a spot where people really just like to fly on the road. It's a 40-mile-an-hour road, and people all the time, they're flying 50, 60 miles an hour on this road.
Neighbors like Ryan say people are constantly speeding down this stretch of Superior Road, and if they hit the tracks just right, there can be problems.
I've witnessed people get air on these tracks. If they were going fast either direction, they could easily have gotten airborne and lost control that way.
What ultimately caused them to lose control is under investigation, but preliminarily, this is what the sheriff's investigation looks like. They believe the teens got into a fender bender with another driver prior to this and did not stop, instead driving away fast. The other driver tried to catch up with them, but by the time that driver found them, they'd gone off the road through a ditch, flipping over. The Sheriff's Department says 2 of the girls, 18 and 19, were dead at the scene, and a third, a 15-year-old, was rushed to the hospital in critical condition.
On September 2nd, 2022, John Torres was charged with 2 counts of reckless driving causing death, more than 1 year after a tragic accident took the lives of 2 young women. After 15 hearings spanning 14 months, Mr. Torres entered a no-contest plea to 1 count of leaving the scene of a property damage accident on November 20th, 2023. Under Michigan law, the crime of reckless driving causing death requires each of the following elements to be proven beyond a reasonable doubt. The defendant was driving a motor vehicle. The defendant drove the motor vehicle in willful or wanton disregard for the safety of persons or property. Willful or wanton disregard means more than simple carelessness, but does not require proof of an intent to cause harm. It means knowingly disregarding the possible risks to the safety of people or property. The defendant's operation of the vehicle caused the death of the victim. To cause the death, the defendant's operation of the vehicle must have been a factual cause of the death, that is, but for the defendant's operation of the vehicle, the death would not have occurred. In addition, death must have been a direct and natural result of operating the vehicle.
It does call the case of the people versus John Torres. Your name, sir?
My name's John Torres, Your Honor.
Counsel, you want to state your appearance?
Good afternoon, Judge. My name is Joshua Van Lon. I'm standing in for the attorney of record, Mr. Brian Daly, on behalf of Mr. Torres.
All right. Have Mr. Torres, have you read the pre-sentence report in this case?
No, I haven't.
Counsel, do you know if? Go ahead. Okay.
Mr. Torres, the conversation we just had when I got off of Zoom and I spoke with you about what was in the report. Do you remember that?
Yeah, Bailey, I did. Yeah, I'm sorry about that. Yeah, I talked to him about it. Yes.
Okay. Go ahead, Ms. Blair.
Yes, Your Honor. I would just like to indicate to the court that the deceased victims' mothers are present and they would like to address the court prior to sentencing.
All right. Very good.
Good afternoon, Your Honor. I'm Rochelle Wilson from the Prosecuting Attorney's Office, Victim Advocate. I've been asked to read the statement into the record.
All right. Go ahead.
Thank you, Judge. Victim impact statement for the loss of Alexis Hinton and Patience Lund. Coming up with words for this particular statement was considerably more difficult than we imagined it would be. How do you put a metric or a value on life, on 2 or 3 lives? If we're being honest, it feels like they slipped through the fingers of our society and it's taken us to a dark place. In a perfect world, we would have all the answers. We would know why John Torres was chasing our girls. It would never bring us peace, but we could find a way out of the gloom and the shadows that the unknown tends to cast. Accidents happen every day, but does he bear responsibility for contributing to what happened on August 2nd, 2021? This is the unfortunate side of perception and how subjective it can be depending on one's viewpoint. But as big of an injustice as it was not to have a higher severity of charges, it would have been an even greater insult if the max sentence wasn't applied here. Thank you, Judge.
Come up to the stand. Counsel, is there anything you or your client want to say before I do impose sentence?
Yes, if you don't mind, Judge, thank you. And first up, it's not lost on me the fact that there are families there that lost their children. And I've been to your court a couple of times about this case, and the families have been there, and they've been respectful to me, and they've been respectful to Mr. Torres. So I want to make sure I make that clear. And I mean no disrespect in the way that I advocate for my client. I know you know me, Judge, and I know you know that, but I want to make sure they understand that. This is a case where the prosecution themselves dropped the charges on the reckless driving causing death. My client pled to a failing to stop at a property damage accident. There's not a victim to the failing to stop at a property damage accident. The evidence is what it is about what happened that day, and it is sad what happened. It really is. But he's not here because of a reckless driving causing death. He's here because he failed to stop at a property damage accident. And Judge, I'd ask that you sentence him for that. I mean, to ask for jail time, even the recommendation from probation, it just seems, I mean, that we're linking two things that aren't linked. I mean, this is not, Mr. Torres never would have entered a plea to something that put him at fault for this accident or responsible for this accident. This isn't the accident we're talking about. The accident that he failed to stop for is the rear end collision that happened when he was struck from behind with the truck. It wasn't failing to stop for the accident that resulted in these girls' death. It wasn't that at all. The plea was based on the accident that happened before that. And so, again, I can't state enough that it was painful to read the police report and to see what happened as well for me, and I feel bad for the families. But Mr. Torres isn't here being sentenced for that, Judge. So I would ask that you sentence him to fines and costs, as you would with a failing to stop in a PD accident.
But counsel, let me just, I understand, I guess, the argument that you make, but as I understand factually here, there's a rear end collision, and whatever the circumstances that transpire in that sort of brief moment, there is then the vehicle that the victims are driving that goes past Mr. Torres. And then there is, as I understand it, there's sort of this high-speed thing that happens. I guess I say that because it seems to me, and one of the concerns that I have with it, and while it may not, I guess, legally fit within the definition of reckless driving causing death, that but for those young ladies feeling that they were chased, the rest of it doesn't happen.
And Judge, respectfully, I disagree. I believe that's the facts that the prosecution, that they have in their police report. I don't believe that's the facts that the evidence shows. The evidence shows that after they took off at a high rate of speed on their own without him following them. Then he took off, and only evidence they have after that is that somebody says from a camera, it appears that he's also traveling at a high rate of speed. But the evidence also shows that none of the vehicles that saw that truck going down the road where it ultimately crashed, none of them saw Mr. Torres's vehicle on that road. He said he turned around on that road, but that was when he lost sight of that vehicle. We have an allegation that that he was following them at a high rate of speed, and that's it. But that's after this accident happened, Judge. I mean, that what he pled to was leaving the scene of the rear end collision. And I don't want to put the blame on anybody in this situation, especially such a horrible situation. But I don't think we need to put the blame on anybody for that, Judge, because we're not here to deal with that situation. And I don't think Mr. Torres's actions after the fact did cause or are responsible for that accident. And if they were, I think the prosecution would have at least attempted to prove it. And I don't mean anything negative towards the prosecutor. the way I say it that way. Sometimes when I say things, they come out very, very harsh, and I don't mean that to be that way. I think what we have here is exactly what it is, Judge, an accident. It's an accident. Mr. Torres didn't have any blood, any alcohol or drugs in his system that day. It was a rear end collision, and I think that they didn't want the cops called on them, and so they took off, and he followed them until he couldn't see him anymore. I don't think that is something that warrants jail.
But counsel, I don't mean to quibble, but certainly in terms of how the court views this, what I hear you saying, which is different from my impression in reading through the report and everything that I see here, is that your client's actions did not cause in any way the victims in this case to do anything. Even if it was, let's say they took off at a high rate of speed, that they continued at that high rate of speed because he was behind them. I mean, what I'm hearing you saying is the fact that your client was there had nothing to do whatsoever with what ultimately occurred.
I don't think that would be an intelligent thing for me to say. You're right, Judge. What I'm saying is I don't think that the fact that my client decided to follow them after they left the scene doesn't result in them getting in the accident that they got into. The accident, by all accounts, by everybody who saw it, the accident happened when Mr. Torres had already turned around. He was gone already. I mean, it's not that the accident happened because he was chasing them. It's because the accident happened on their own. And
I want it clear as I read it. The car with the young ladies continued to proceed because in the manner it did, because he was behind them. Now, granted that the accident that ultimately occurs may have occurred at a later point, I think is something different.
And Judge, with all due respect, I don't believe that the report to be evidence in a situation. That was a disputed fact. That's why it was reduced or taken. That's why the reckless driving causing deaths were taken back, is because they couldn't be proven. There is absolutely nothing in the police report about Mr. Torres. Anything that goes beyond Mr. Torres simply following them and then losing sight of them. Anything else is a disputed fact. We would have disputed. We would have taken that to trial. I mean, we ultimately pled because the charge was brought down to reckless driving, and we worked out the agreement to the failure to stop at the PD accident. At no point was this plea ever based upon any actions that were taken after the fact. But even if it were, Judge, those are disputed facts. The fact that they put it in a police report, with all due respect, doesn't make it true. And the fact that the person who wrote the PSI took that information from the police report doesn't make it true. There was a very good argument, very, very strong defense that the things that were in that police report actually were not what happened, based off eyewitnesses who saw the truck on the road before it crashed, based on eyewitnesses who saw Mr. Torres not on that road at all.
I understand that there might be disputed facts, but in order for me to properly sentence, I have to, in my head at least, have some resolution of the facts as they've occurred, or at least how I perceive that they occurred. Otherwise, I just sentence on a charge and forget the rest of it. The failure of Mr. Torres to remain where he was, what then happened?
I don't believe that. Oh, I'm sorry,
Go
Judge.
ahead.
I thought you were asking. I apologize. I did not mean to interrupt.
No, go ahead. Go ahead.
I think, and you may disagree with my answer, but the answer to that is what was going to happen was going to happen, because our version of the facts, what we believe to be what happened is, and I'm trying to walk very fine line here so that I'm not trying to dig into anybody, but the reason that the girls wanted to leave the initial traffic stop is because they didn't want to have the police come, because there were some, they're kids, they were doing some things that kids do, and they didn't want that to be the issue. So when they left the scene at a high rate of speed, the initial accident, they were going to continue to do that because they didn't want to have to go back to that accident scene.
I get it, counsel, but the problem I'm having here is you're telling me when I read the report, when I read the rendition of what transpired, I shouldn't take into account things that I see here that give me a bit of pause. And even in terms of just the charge really is that he didn't just stay where he was and report it.
Can I say something?
Your client wants to speak. Do you have an issue with that, counsel?
Yeah, no, don't say anything at the moment, please. Judge, I think part of the reason that you don't see that there is because you're getting one version of the facts when you look at the police report. And I see your difficulty, Judge. It's tough because this is a sad situation, but that's not what he pled to. And had he known that this was going to be a situation where he has to answer for, why things ended up the way they did, instead of just focusing on the leaving the scene of a property damage accident, he wouldn't have made that plea. If somebody rear ends you and then they take off and you follow them, there's nothing illegal about that. And if those people choose to run away at a high rate of speed and get in an accident, that shouldn't be the person's fault who chose to follow them. And that person shouldn't have to go to jail because they chose to follow them.
And under your version of this, how far did he follow them?
According to the reports, he turned around on the street well before the railroad tracks, and the oncoming vehicles that passed the truck before it was in the accident did not see Mr. Torres's vehicle on that road. I think what we're doing is we're taking it and we're moving forward with facts that absolutely 100% would have been disputed at preliminary exam and at trial had we known that they were going to be facts that would be considered. And that being the case, Judge, I would have preferred, if these facts were going to be considered, I would have preferred to have an evidentiary hearing on it, or a contested hearing. And that's actually what we initially elected to do before they dismissed the charges. So now those same facts that I initially wanted to contest are being used against Mr. Torres and accepted as true. And I'm not saying you shouldn't be able to do that as the judge. Obviously, you're the decision maker, but that's why we didn't move forward with a plea to anything or with a hearing as to anything, because when we set the case for a hearing on those disputed facts, the prosecution then removed those charges.
Okay, I hear you, but I don't know why, and I don't know that it's up to me to try to figure out why charges get reduced, because there are various reasons why that happens. And because they're typically not at our sentencing, I'm not hearing from the prosecution regarding their side. And then if I hear that, then certainly I can, because it's what I do, I can try to resolve that in my head to see if it makes a difference. I think I'm going to need, to start out with, I'm going to need a prosecutor present. I will leave that to you to make the decision as to whether or not you wish to withdraw the plea and send this back up on either the felony charges or something else. But I can't, my intent was to follow the recommendation of probation at least. And I hear what you're saying, that if that's what the court's going to do, you want an opportunity to maybe do something different. I'm going to suggest, counsel, that maybe you speak with the prosecutor's office so that maybe there can be some understanding that the court could have. I'm going to adjourn the sentencing, and if you can't, then at least you understand where my head is, at least at this given moment. Then you could maybe file your motion to withdraw the plea or do whatever. I give everybody the opportunity. I will adjourn this to January 24th.
2 weeks later.
Court does call the case of People versus John Torres.
Patricia Reiser on behalf of the people.
Good morning once again, Judge Joshua Van Lon on behalf of Mr. Torres, who's present in court.
Torres, can you state your name?
John Torres.
All right. I understand a couple of things. First of all, that the moms they're present in the courtroom. I know you addressed the court the last time and we adjourned it out for reasons. Was there anything else either of you want to tell the court? Again, you most certainly can address me again. I want to make sure you get.
Our statement that we wrote was kind of addressing everything for all of us. Sherry, the other mom, they had car trouble, so she's watching it on your YouTube.
Oh, okay. Very good. Very good. Did you have any questions for me? Okay, come, I need you to, it's okay. I figured you might, and so I want to make sure I address the question.
So, one of the questions. Sorry.
Yeah. No, it's okay. Can you state your name first?
Yes, Christy Green.
Thank you. Go ahead.
You're welcome. So when you say like he wasn't, his proximity to the accident, are you talking about the second accident?
I'm talking about the second accident. So,
Okay.
so just so you understand where I'm coming from and what I now
Yep.
see. There's the rear end collision, right? And then after that rear end collision, the first car, which your daughter was in, takes off. That Mr. Torres, as I understand the facts now, goes some distance, but isn't in the area when the accident, the fatality occurs. Which is a whole different impression than what I had initially.
Okay.
Okay, so go ahead with your question. I'm sorry.
Okay. So are you aware that it wasn't a hit and run, because there's two different police reports, right? So there's Ypsilanti. Ypsilanti had it as a hit and run, but then there was a fatality through Superior Township, right? So
The sheriff's department, right?
So when they investigated, because we had sat down with the prosecuting attorneys and we went through this and we actually asked quite a few questions when they were originally dropping the charges from the misdemeanors. But they called us in to sit down and discuss all this a while ago. So at that point, we asked quite a few questions. And it's my understanding that from Eastern, there's video footages that see when my daughter hit him, they stopped. They got out of the vehicle, they went back and forth. The detective had Mr. Torres's phone and verified that there was a picture of the license plate that was taken in his phone prior to him chasing them or following them or whatever it is that we're calling that right now. Are you aware of that?
Let me tell you what I am aware of.
Okay.
As at least, again, as I understand it, that there's the initial accident.
Yep.
My understanding is that there was some contact between the parties to that.
Okay.
It was basically a failure to stop at the scene of a property damage accident, because the law requires that certain things have to occur or the person has to do something
The first
at the
accident.
scene. Right.
Okay. So then you said something about the second accident. So all we're talking about is the first accident, because you said he wasn't in proximity of the second accident. And I don't know how.
That's what the data, that's what I see from the data.
Okay, so the first driveway, if you're to pull on that street, he would very clearly been able to see what happened. So I just want to make sure we're not talking about that, because I don't.
See what happened. Okay.
The second accident.
The second accident?
Yes. He was with it.
Whether or not one could see it or not, he was not in proximity to that accident.
What would you consider proximity?
That he's a distance from that accident.
What just
well, I can't give you I can't lay it out by feet or anything like that, so I can't say that. What my understanding, the facts are, is that he's some distance from when the accident occurs. Now, hold that thought for a moment, okay? Because my initial reading of this was that the cars take off, right?
Mm-hmm.
And that he is indeed following them, but doesn't stop.
Correct.
Right? My understanding is he stops at some point and the accident occurs further down. But at the point that happens, he's not, whether you want to call it in pursuit, chasing, following, he's not doing that at that point. That's my understanding now. Now, if you believe that there's something that says something different, then I certainly want to see it. But that is when I'm now looking at everything, that's what I see.
Okay, I don't believe his vehicle. I think it was too old to have a black box in it that would show where he actually was.
That's the data from the accident reconstructionist says something different than what my impression was. That's what I'm.
Okay, so then maybe I didn't see that, but the driveway that he clearly said he pulled in, I would say is 10 car lengths, 10 car spaces from where the accident happened. So you can say close proximity, not close proximity. We could all have a different understanding of that. So I disagree with that statement because I think it's based on how we would personally look at it. So I just wanted to clarify that, but I don't know that that's going to make a difference in what we're doing sentencing right now for.
Let me just tell you this, ma'am, and I'm just kind of a straight shooter about things.
I appreciate that.
This whole case troubles me, right?
Yeah.
And sometimes I guess it would be great doing this job if I weren't a human, because then I don't have to deal with things that I have to set aside in my mind.
I understand.
Parent to parent, I'll just say this. After we were here the first time, I could only think about my daughter. And that I would want something to happen. I'm not even sure I'm not even sure what I would want, right?
Yeah.
But that I would. And I had to people I think that when judges leave the bench, we kind of leave everything behind us and we don't think about things. This one has been with me. I want to say a lot, but I think it's been sitting in the background. And on just all my thoughts. But I also realized, in great part, setting that emotion aside, I realized I had to do my job, right? And I also realized that if I could, but I know I can't, that I don't have the power to bring back who you lost. In a lot of ways, sitting here is a helpless feeling, because it really doesn't matter what I do.
How I feel.
Hmm?
That's how I feel.
I can't make it right, and I know I can't. I realized that being limited in that regard, that all I can do is try to make the correct decision. And while this may sound crass, I don't mean it this way, but it's the best words that I can come up with, and then let that fall where it may. And the way for me to do that is to try to make sure I have a clear understanding of, as best I can, what happened. If, and I said this before, if my impression that I had initially was that there's the rear end collision, and then at some point this chase happens, and I purposely use that word chase happens, then the consequence of that chase may rest with Mr. Torres, right? That's one scenario. The other scenario is the initial accident happens, and then there may be this brief moment, and you're right, they're out of the vehicles at some point. Then there's this brief moment where the vehicle takes off. He may even be headed in the same direction, but then stops, calls the police. Under that scenario, he wouldn't then be attributable, or it wouldn't be attributable to him, and he wouldn't be the cause of it. When I went back, and like I said, I'm just trying to do the right thing. And when I went back and looked at everything, it's that second scenario that I'm seeing. And if you think that there's something else that I should look. I looked at everything, but if you want me to look at something else before I close sentence, I will do it.
Thank you, and I appreciate that.
All right.
Can you grab my phone? I want to make sure that Sherry, she's watching. I want to make sure that she doesn't have anything to say. So the question that you're asking about.
You're in communication with her then?
Yes.
Okay.
Yeah, she's watching on Zoom.
Did she want to sign in? I mean,
That's what I'm trying to find out right now. I don't know if you want me to step out and make a call or if you want me to do it from right here.
You want to call her to see?
Yeah.
Okay. If you want to step out, you can make a call. Go ahead.
Thank you.
Sherry did join.
Oh, she joined. Okay. Let's see. Where is she? Oh, there you are. Okay. Now everybody's here. Okay. Did you have a question, ma'am, or something else you want to tell the court? I think you were listening to what I said before.
I would really like for the initial phone report when he called into 911 to be relooked at, because from my understanding in that 911 call, admits to the chase. He admits to turning in the driveway before the railroad tracks, and he admits to seeing some dust. So what dust did you see if they're on a paved road and you're not on a dirt road? The dust you saw was them going over them railroad tracks and crashing.
So what you're asking me, just so that we're clear, you want me to, if it exists still, you want me to listen to that 911 call?
I would love for you to listen to that 911 call. I mean, I know at this point it's probably not really going to change anything that we're looking at, but at least to get our understanding heard and maybe get a different look at it. If you're admitting to it and you tell them you turned around in the driveway before the railroad tracks, which is where they crashed, none of it just sits well with anybody.
I will absolutely do what I say I'll do. And so, Ms. Reiser, how long would that take you to get that to Ann so that I can hear that?
I think I can email it. I can try to do that.
Okay, if you can get that to us, if it has to be on a drive or something, then we'll just have to do it that way. It doesn't matter to me. I just want to hear it. They want me to do that. Yeah, I will be adjourning it, if that's okay with everybody.
I'm sorry to interrupt.
Well, if it's not, that's what I'm going to do anyway. So I'm going to adjourn it so that can get to me. I'm sorry, your last name again? Green?
Yeah.
Yeah, because I can't remember simple names, right? Ms. Smith, Ms. Green, is there anything else you want me to look at or any?
Able to watch the videos that they have from the campus of the actual first initial rear end?
Okay, you want me to watch the videos? Okay, so what would you be asking me to look at regarding that?
Because from my understanding, he also waves them to go around him once they all get back in their vehicles. So if they all get back in their vehicles and he's waving them to go around him, why are you waving them to go around you?
Okay, so let me ask you this. What would you want me to do with that information? Let's assume that that's true. What would you want me to do or draw from that?
So him leaving the scene of an accident, if you're waving them around, you're basically telling them, go ahead and go. So they leave, you leave, and then you proceed to call 911. If you're waving them to go around, that's basically you saying, go, everything is okay. That's like a setup. So basically you set them up. If you're waving them to go around you, you're basically saying everything is okay. So then you call the police after you wave them to go around you.
Okay, but what do you again, assuming what you're telling me is the truth, what would he be your theory about what he's setting them up for?
We don't know what that's what the initial thing is. Why did you wave them to go around and change? I just want you to look at all aspects before you final sentencing on your decision.
Okay, I mean, I'll look at, I went through stuff And, I'm just gonna let you ladies know, I normally don't do this. I get my report, I look at my report, I kind of have my thought process as to what's occurred, and that's what factors into my sentencing, but I'm willing in this instance to go beyond where I would normally go because I want to get it right. So what I will do, Ms. Reiser is going to get those two things to me. My next date will be
February 14th at 9 a.m.
February 14th. So I'll adjourn it to February 14th, 2024, 12 noon.
All right, thank you,
All
Judge.
right. Thank you.
Thank you.
You got that for us? All right. Thank you, folks.
3 weeks later.
Court does call the case of the people of the state of Michigan versus John Torres.
Good afternoon, Your Honor. Patricia Reiser on behalf of the people.
Good afternoon, Judge. Joshua Van Lon on behalf of Mr. Torres, who's present in your courtroom.
Can you state your name, sir?
John Torres.
All right. This is the adjourned sentencing date. There was statements given by the mothers of the two young ladies to the court. They asked the court to look at additional information, which the recordings of 911 were sent to the court. The court had reviewed them. Was there anything else from either side before the court goes into its decision? Anything from the people?
No, thank you, Your Honor.
Anything from the defense?
No, Judge, you've given us ample time. Thank you.
There isn't an easy way for the court to say this, except for to say that, well, first of all, and I'll give everyone another opportunity to speak after I say what I'm going to say and what the court looks at, what the court has at least surmised. The defense's position is that certainly the defendant ought to be sentenced on the charge that he pled to. Much of that, frankly, I guess bears on the concept, or at least what has been said, that the defendant, Mr. Torres, was not in a position to see the accident. And that he was someplace else, which led to the plea. And again, it's not the court's province to get involved in what the particulars of the charge are, but to try to do its best to mete out a just sentence. Part of the reason also that the court had made a determination to at least hear the 911 tapes. I have a copy of the police report as well as Mr. Torres' statements. Was because I was going, and I said to the parents that there may not be anything that the court could do, but you were going to be heard by this court. And in doing that, some things, as I saw them, were a bit disturbing to me. And, I'm not in, nor should I be, in a position necessarily to do some investigation to try to figure out what transpired entirely. But initially, in listening to the 911 calls, particularly there were a few other calls, but I listened to Mr. Torres' call to 911. And that initially caused me some concern about whether or not the defendant saw this accident. And here's why. Mr. Torres initially contacts 911. And what was said to the court by Mr. Torres and what he had maintained to probation is that he didn't see this accident. I'm having a very difficult time believing that. And let me explain my reasons why. Defense counsel, I think, properly stated before that that Mr. Torres had called from someplace else. Mr. Torres contacts 911. It's an odd call because of the way that I think the dispatcher was responding to Mr. Torres. One of the things that was said is Mr. Torres put himself at First Street off of Superior. The dispatcher says that's not where we have you. Put a pin in that because that becomes important in the court's mind. At some point, Mr. Torres then says, I'm at First Street. He is then headed back to the location of the initial contact between the vehicles. Okay. All of that being said, I then review the police report and Mr. Torres' statements. And if everyone can recall, one of the things that the court was looking at was, did Mr. Torres chase these individuals and cause this accident? One of the things that was said in counter to that is that he's not near the accident, doesn't see the accident. Again, I'm having a difficult time believing that. And part of the reason I'm having a difficult time believing that is because there is an EMU security camera that's referred to in the police report that has these vehicles traveling down Huron River Drive, both at a high rate of speed, because Mr. Torres is in an Equinox, I do believe, and there's a truck. At some point, they get to the corner of Huron River Drive and Superior. According to Mr. Torres, it is a red light. The truck stops. He stops at some point. The truck continues through the red light. Mr. Torres indicates from the report, at least as I read it, that he then turns on a green light. Now, how that certainly all could happen. Bottom line is that they're then, Mr. Torres indicates in the police report that at some point on Superior, he disengages from, as he puts, following the vehicle. It's best the court's able to determine the distance from that corner of Superior where the turn is made to the railroad tracks. It's approximately 1,000 feet. Mr. Torres is then, if he is correct, and he is saying where he is to the dispatcher, this is where we take the pen out of that he's at First, but the dispatcher is saying that's not where we have you. Mr. Torres is further up that road. But even if I give the defendant the benefit of the doubt that as far as he went was First, the railroad tracks are approximately 100 feet from that location. It is a clear shot from that location to see those railroad tracks and that intersection. It is not as though there is a crest. It is as though there is something that from First would obstruct one's view. The other thing that was specifically asked of Mr. Torres is he made it very clear that he did not go over the railroad tracks, but the additional thing that was asked is whether or not he crossed a bridge. Mr. Torres says he did not cross a bridge. That can't be true, because as you're going up Superior, to get to First, you have to cross the bridge. Moreover, when Mr. Torres is later questioned and talking to the dispatcher, he had to not only cross that bridge once, he had to cross it twice because he had to go over the bridge and he had to come back to get to the location where it occurred.
Can I say something, Your Honor?
In a moment.
No.
Moreover, when you listen to the other 911 calls that are called in, two vehicles that are traveling to the south, so they're traveling the opposite direction from the Getty's roundabout. They see the vehicle go, well, basically off the railroad tracks and have the accident. From really, and honestly, I mean, I don't know exactly where they are, but from putting again the defendant where he says he is, they are at a much further distance from those tracks than would be Mr. Torres. He's much further, let me preface this by saying, through the other hearings, it was stated to the court that he is nowhere near the tracks and that he is further from the tracks where this occurred. That can't be true and everything else be true. It just can't be. He is within 100 feet, really between 80 to 100 feet of that intersection when that vehicle goes off the road. And it also is perplexing from the court standpoint. I thought I understood it initially. When Mr. Torres is telling the dispatcher that he has the license plate of the other vehicle, one is thinking, or at least I was thinking, that he is getting that license plate by following the vehicle. That's not the case. He actually had the license plate of the vehicle prior to it turning onto Superior. Hence, realistically, there is no reason whatsoever for him to have continued up Superior behind that truck. If somebody, and counsel, I will give you an opportunity to address the court on that. And like I said, I'm not here, and I explained to Mom, it's not my province regarding the charge. My province is to meet out the sentence with what's in front of me. The court at this point is of the opinion that Mr. Torres saw this happen. When he talks about the kicking up of dust and other things, the only place in that area that's going to happen is basically at those tracks. It's not going to happen on the turn off of Huron River Drive onto Superior. And, you know, and I'll just say it. When I look at all of this, I'm having a hard time believing that he's telling me the truth. Ms. Weidling, can you just put that GPS up?
Can I say something?
I'll let you, if your counsel believes that should speak, then I will let you speak. But at the very bottom of the screen, you're going to see the turn from Huron River Drive onto Superior. Up at the top of the screen, you'll see the railroad tracks. And if you look down from the railroad tracks off of Superior, that first street coming off, which would be as you're looking at the screen to the left, that's First Street. From there, you can see that there is a clear shot to that intersection with the railroad tracks. If Mr. Torres is there, he has a clear shot to that whole area. When you also look at it just in terms of his timing of the calls, the other calls that are coming in, he can't not be in that area and see what happens because the other calls come in shortly thereafter and they're traveling north from the Gettys area, traveling southbound on Superior. They see it. I'm not here to worry about what's charged, what's not charged. I have to mete out the best sentence I can with what I have. And I will let you know, and counsel, I will give you an opportunity if you want to somehow or another speak with your client prior to the court imposing sentence. But I do believe that jail time is appropriate given what I see. I can't, in giving that, I can't bring back these young ladies. And I told the parents, I can't do that. But I certainly can do the best that I can to make sure something occurs. If I believed that Mr. Torres was not present, that it was as it was portrayed to this court, a circumstance where he could not have seen it, that he would have been so far down on Superior that he wouldn't have seen the railroad tracks, then that's where I would land. And I would have no problem landing with that and justifying it. I can't, based upon his own statements, justify that as being true. He had to see it. He's telling me he's 2 to 3 cars behind them, that he's following them, and that he's at first, and it's a clear shot to those railroad tracks. If somebody wants to tell me how I can come to a different conclusion, then please tell me that. But I can take into account in terms of sentencing whether or not a defendant is being truthful with the court in terms of what they're saying. And I will be blunt. I'm just a plain talker. I don't believe that he is. Counsel, if prior to Mr. Torres is, I don't know that you can see him or not. He really wants to make a statement. I will arrange, counsel. I know you don't want him to. If you want, because since you're not here, if you want to talk to him, I will arrange to get him on a Zoom and get you guys into a breakout room so you can talk.
No, Judge, that's fine. I'm ready to make a comment when you're ready to hear it. I don't need.
Oh, go ahead.
Judge, with all due respect, this is wildly inappropriate. For you to be doing an investigation on your own, for you to be pulling up.
Counsel,
go ahead, Judge. You're the boss.
Counsel,
Yes, Judge.
Stop a moment. I think I acknowledged that. I'm not here doing an investigation. The question is what was represented to this court is that he could not have seen it, that he was not following them. Anything that I have here is not an investigation. All I did was listen to the 911 and read the police report. So in that case, if you think that's inappropriate, then fine, you can go ahead with your statement. And then I will proceed to my sentence.
Right. In addition, Judge, you pulled up a map and you said that it's impossible to see, or that it's possible to see where the accident was without actually being at the scene viewing it. There was no trial. There was no any opportunity for the defense to present you with counter evidence or anything like that, Judge.
Counsel, what do you want to give me? What do you want to give me?
I don't want to give you anything.
What do you want to give me? No,
Judge,
counsel, if you're going to say I'm being unfair, what do you want to give me?
Judge, I want to tell you that I don't believe you should be considering anything that will occur after this.
What you represented to this court, and I realize you're advocating for your client about him being someplace further from that scene, it's not true. It's his own statements. These are not anything where I went out there and I'm looking at something or I'm doing whatever. It's just placement. He's saying he's at first. I just listened to the tape. I didn't do anything. I didn't go out there and investigate, talk to any witnesses, do anything like that. I did that and looked at a map. That's all I did.
Right, Judge.
So if you want to give me something, counsel, you can come here 2 hours late. Give me what you want to give me.
Judge, I don't believe you should be considering anything after the fact of the initial accident. He's being sentenced for failure to stop at a PD accident. It has nothing to do with what he did afterwards. It's completely inappropriate for the court to be.
What he did afterwards?
After the accident, when he was initially rear-ended, that's what he pled to, failing to stop at that accident. It's not failing to stop at the accident that the girls were involved in. It's failure to stop at the accident where he was rear-ended. Ms. Reiser agrees.
If your client, knowing what I'm going to do, wishes to withdraw his plea, I will consider that motion.
Judge, I would also ask that you recuse yourself at this point.
Denied.
Understood. And I can, if you wouldn't mind allowing me to speak with Mr. Torres, my guess is he's going to withdraw his plea.
I'm sorry?
If you wouldn't mind allowing me to speak with Mr. Torres to make sure this is going to happen, but my guess is he will withdraw his plea.
Can we set up a breakout room for Mr. Torres? We're going to put you into one of the conference rooms out there, into a breakout room, and put your counsel into a breakout room so you guys can talk.
1 hour later.
We're back on the record in the Torres matter. Counsel had an opportunity to speak with his client. There's been also an opportunity for the court to speak with counsel. They are going to consider a motion to withdraw the plea or the other end alike. The court is going to give the opportunity for them to file the written motion to do so if necessary. I'm not saying that that's what they're going to do, but give that opportunity. So I'm going to adjourn these proceedings for the motion as well as sentencing. I'll set both at the same time to March, my next sentencing, March 13 for a continuation of the proceedings. I have directed counsel that everybody needs to be in person. at that proceeding.
Understood.
All right. Bond will continue. Thank you.
All right, thank you, Governor.